Welcome to our detailed series on the Indian Constitution. Today, we're tackling one of the most crucial sections for any UPSC aspirant. Part 5, which deals with the Union government, running from Article 52 to Article 151. This part is the bedrock of how our central government functions. We'll explore the Union Executive, the Parliament, the Supreme Court, and the Comptroller and Auditor General of India. I'll break down each article and link it to landmark Supreme Court cases that have shaped its interpretation. This is essential for both your prelims and mains. So let's get started. First up, the Union Executive, covered in Articles 52 to 78. Article 52 simply states, "There shall be a President of India." But how much real power does the President have? The landmark case of Shamsher Singh versus the state of Punjab in 1974 clarified this. The Supreme Court held that the President is a constitutional head who must act on the aid and advice of the Council of Ministers. Article 53 vests the executive power of the Union in the President. The case of Ram Jawaya Kapur versus the state of Punjab in 1955 explained that this executive power is as broad as the legislative power of the Parliament. Articles 54 and 55 detail the complex process of the President's election through an electoral college, using a system of proportional representation. Articles 56 to 60 cover the President's 5-year term, eligibility for re-election, qualifications, and the oath of office. A key provision is Article 61, which outlines the impeachment process for a violation of the Constitution. It's a quasi-judicial procedure that requires a special majority in both houses of Parliament. Article 62 ensures there is no power vacuum by mandating that an election for the next president be completed before the current term expires. Next, we have the Vice President from Article 63. The VP, under Article 64, is the ex officio chairman of the Rajya Sabha. This is their primary role. Article 65 specifies that the VP acts as president during a vacancy. Article 66 outlines the VP's election by members of both houses of Parliament. The subsequent articles cover the term, eligibility, and oath. Article 71 is important. It states that any disputes regarding the election of the president or vice president are decided exclusively by the Supreme Court. One of the most powerful provisions is Article 72. The President's power to pardon, commute, or remit sentences, including death sentences. 2 cases are critical here. In Maru Ram versus Union of India, the court affirmed that the President must exercise this power, based on the Cabinet's advice. And in Kihar Singh versus Union of India, it was held that the President can go beyond the judicial record and examine evidence afresh, while considering a mercy plea. Now, let's look at the real executive, the Prime Minister, and the Council of Ministers. Article 74 mandates that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President. The Shamsher Singh case is relevant here again, emphasizing that real executive power lies with the ministers, not the President. Another monumental case linked to this is S.R. Bamai versus Union of India in 1994. While primarily about Article 356, it reinforced the principle of collective responsibility and strengthened federalism by curbing the arbitrary dismissal of state governments. Article 75 is the linchpin. It says the President appoints the Prime Minister, and on the PM's advice, other ministers. Crucially, it establishes that the Council of Ministers is collectively responsible to the Lok Sabha. This means the government must always enjoy the confidence of the lower house. The case of UN Rao versus Indira Gandhi confirmed that the Council of Ministers must command a majority even when the Lok Sabha is dissolved. Article 76 provides for the Attorney General for India, the government's chief legal advisor. Finally, Articles 77 and 78 outline how government business is conducted and the PM's duty to keep the President informed. Moving to our second major component, the Parliament, covered in Articles 79 to 122. Article 79 defines Parliament as comprising the President, the Rajya Sabha Council of States, and the Lok Sabha House of the People. Articles 80 and 81 detail the composition of these two houses. Following that, we have articles on readjustment after each census, the duration of the houses, and the President's power to summon sessions, prorogue them, and dissolve the Lok Sabha. Articles 86 and 87 deal with the President's address to Parliament. Following this, we have articles on the officers of Parliament: the Chairman, Deputy Chairman, Speaker, and Deputy Speaker. A key set of articles, 99 to 104, covers oaths, vacancies, and disqualifications of members. This is where the anti-defection law comes in. In Quixote Holohan versus Zakilhu, the Supreme Court upheld the validity of the 10th schedule, but ruled that the Speaker's decision on disqualification is subject to judicial review. Article 105 discusses the powers and privileges of Parliament. But are they absolute? The case of Rajya Rampal versus the Speaker of the Lok Sabha in 2007 established that parliamentary privileges are not immune from judicial review, especially if they conflict with fundamental rights. Then we have provisions for salaries and the crucial Article 18, which provides for a joint sitting of both houses to resolve a deadlock over a bill. Next, we dive into the legislative procedure from Articles 109 to 117. This section explains how bills become laws. A very controversial topic is the money bill, defined in Article 110. Only the Speaker can certify a bill as a money bill, and it can only be introduced in the Lok Sabha. The Aadhaar case in 2018, where the Aadhaar Act was passed as a money bill, remains a landmark judgment, though its reasoning is highly debated. Article 111 details the President's power to give assent to bills, including the power to withhold assent or return a bill for reconsideration. Articles 112 to 117 are about financial matters, including the annual financial statement or the budget. Finally, Article 123 grants the President the power to promulgate ordinances when Parliament is not in session. This is a legislative power, but it's temporary. Two cases are vital here. DC Wadhwa versus the State of Bihar in 1987 declared the repromulgation of ordinances without placing them before the legislature as unconstitutional. More recently, in Krishna Kumar Singh versus the State of Bihar in 2017, the court held that every ordinance must be placed before the legislature, and no rights can be claimed based on an ordinance that has lapsed. Our third pillar is the Judiciary, specifically the Supreme Court of India. From Articles 124 to 147, Article 124 deals with the establishment and constitution of the Supreme Court, including the appointment of judges, which has been a topic of debate with the collegium system. Article 129 makes the Supreme Court a court of record, giving it the power to punish for its contempt. The jurisdiction of the Supreme Court is vast. Article 131 covers its original jurisdiction, primarily in disputes between the center and states, or between states. Article 136 grants the power of special leave petition, or SLP, allowing the court to hear an appeal against any judgment from any court or tribunal. The case of Pritam Singh versus the state in 1950 clarified that this power is to be used sparingly, not as a regular right of appeal. Article 137 gives the Supreme Court the power to review its own judgments, though this is exercised in very rare cases. The most significant powers are arguably in Articles 141 and 142. Article 141 states that the law declared by the Supreme Court is binding on all courts in India. Article 142 gives the court the extraordinary power to pass any decree or order necessary for doing complete justice in any case before it. This power was used in the Union Carbide case for the Bhopal gas tragedy settlement and in the Prakash Singh case to order nationwide police reforms. Article 143 allows the President to seek the advisory opinion of the Supreme Court on a question of law or fact. Finally, we have the fourth institution, the Comptroller and Auditor General of India, or CAG, covered in Articles 148 to 151. Article 148 ensures the CAG's independence, making it a bulwark of the democratic system. Dr. Ambedkar called it the CAG, the most important officer under the Constitution. The CAG's main duty, under Article 149, is to audit all receipts and expenditures of the union and state governments. The CAG's audit reports, as per Article 151, are laid before Parliament and state legislatures and are examined by the Public Accounts Committee. The CAG's role is not just to check for legality, but also for financial propriety and wisdom. So, to summarize, Part 5 of the Constitution lays out the entire machinery of the Union government. We have the executive, headed by the President but run by the Prime Minister and the Council of Ministers. We have the legislature, Parliament, which makes laws for the country. We have the Judiciary, with the Supreme Court at its apex, acting as the ultimate interpreter of the Constitution and guardian of fundamental rights. And we have the CAG, the watchdog of the public purse. Together, Articles 52 to 151 create a system of checks and balances that forms the very core of our democracy. Mastering these articles and the landmark cases associated with them is non-negotiable for your UPSC journey. Keep rebusing, keep connecting the dots, and you will build a strong foundation. Thank you for watching. If you found this video helpful, please like, share, and subscribe for more in-depth content on Indian polity. We'll see you in the next one.